Thank you, Mr. Levin. The final witness to testify here this afternoon is Daniel Fleming, president of Fleming Leasing, a truck renting and leasing business located in Springfield, Virginia. Fleming Leasing is a family-owned business founded in 1903. With the transportation services they were providing consisted of a horse and buggy when they started. Mr. Fleming is testifying on behalf of the Truck Renting and Leasing Association. Mr. Fleming, you have 5 minutes to present your testimony.
Thank you, Mr. Chairman. Thank you, Mr. Altmeyer. As you said, my name is Dan Fleming. I'm president of Fleming National Lease in Springfield, Virginia, and our company is a member of the Truck Renting and Leasing Association, or TRALA. I'm testifying today on a troubling aspect of the Dodd-Frank Act, namely Section 1071, the Small Business Loan Data Collection provision. Fleming National Lease is a family-owned business with 18 permanent employees in locations in Springfield, Virginia, and Landover, Maryland. We're a proud member of TRALA, an association comprised of about 550 companies, employing 100,000 people and operating out of 24,000 locations throughout the United States. Not only are nearly all of TRALA's 550 members small businesses themselves, but the vast majority of the customers that we deal with are also small businesses in search of vehicles and equipment offered for rent or lease at a reasonable price. Part of the process in acquiring rented or leased vehicles is to fill out an application of credit. As written, Section 1071 adds extensive new application requirements to the ECOA. These requirements would be offered by and monitored through the CFPB. While they certainly do not operate a bank, under the definitions listed within this new law, I am considered a financial institution because I have an application for credit for my customers. In my opinion, the small business data collection provision is counterproductive, contradictory, costly, and confusing. The provision is counterproductive in that the CFPB was created with the intention of giving consumers protection from the predatory lenders and allowing them to find more options for information in obtaining a loan, but instead is now intended to regulate commercial loans and lenders. Section 1071 is contradictory in that the statutory language conflicts with existing language already on the books. My understanding is that Section 202.5 of Regulation B under the ECOA explicitly says a creditor shall not inquire about the race, color, religion, national origin, or sex of an applicant. The personal information should have no basis in determining whether or not someone receives a truck from Fleming National Lease. In terms of cost, this could cause a real strain on my bottom line. According to Section 1071, after a lender inquires whether an applicant for a loan is a minority, women-owned, or small business, no one involved in the credit decision can have access to this information. This would require me, the so-called lender under this definition, to completely alter my application process, which would be expensive. If we were to comply with this new regulation, I estimate that we would have to, at a minimum, hire a new part-time employee. That could cost our company somewhere between $10,000 and $20,000 annually. And while that doesn't seem much in the scheme of things, for me it's money that could be spent hiring another mechanic or purchasing a new vehicle, both of which in turn makes my company more profitable, but instead would be spent on more administrative burdens. Lastly, Section 1071 is extremely confusing and leaves many questions unanswered regarding what information I am to collect and what definitions will be used to ensure compliance. There also remains a concern over whether or not the CFPB and the Federal Reserve will work jointly to rectify issues that could remain from any exemptions that exist. Just to touch on this final point, since Section 1071 amended the ECOA, both the CFPB and the Federal Reserve now have jurisdiction over entities such as auto dealers. I believe it's imperative that if this new law was to be enacted and enforced, regulators must coordinate their implementation of these new requirements. If not, financial companies might receive different data from the dealers than that which would be required to file with the CFPB and open an entirely new problem. While I recognize the fact that the CFPB has now decided it will issue a formal rule that hopefully will address and answer some of the confusing qualities within the law, ultimately I remain unconvinced that there is even a reason to have such a rule implemented for businesses like my own. I'm not a banker, I lease trucks. To be placed in the same category with a multi-billion-dollar financial giant makes absolutely no sense to me. In my opinion, making a truck leasing company or any small business comply with Section 1071 is a mistake. Thank you for allowing me to issue my testimony today.